So that's enough about TCC. Thank you all for being here today. And again, in line of our mission of education, we are here to listen to Sergio, who is a 34-year practicing attorney here in the South Florida area. The name of his firm is Divorce Lawyers Cabanas Law Firm, and he has 8 locations across South Florida. So if anybody needs to meet with him, again, you could either speak to Miguel or Sergio. There will be a Q&A at the end of this. So if you guys have any questions, write them down. And without further ado, I welcome Sergio.
Thank you. Thank you. Thank you, everybody, for joining us. I appreciate you coming here. This is a topic that's really near and dear to my heart for very personal reasons. So the clip's ready to roll, Sebastian?
Yeah.
A grandmother crying, "Oh my God," over and over while on the phone with 911 dispatchers and a translator.
The girl is pale, she's not reacting.
911 calls capture her pain as she finds her granddaughter's body on the kitchen floor.
Creo que está sin conocimiento, yo no sé qué le pasa, por favor. I think the girl is unconscious. I don't know what is going on.
Well, I'm sending the ambulance.
Family photos capture a once happy Geronimo Duran, his 2-year-old daughter, Melody, and the child's mother. Tonight, a much different picture as Duran is charged with his daughter's murder.
Let people know that there are legal options for them to use to protect children.
And detectives say that the little girl suffered extensive injuries, including a cut to her throat. But it will be the medical examiner who determines exactly what her cause of death was.
I'm devastated. I'm a father, too. I've got 2 kids, and if something happened like that to my kids, I wouldn't know what to do. I'd lose my mind. I just woke up to all these sirens blaring outside of my house. Of course, I thought the police were surrounding what I thought was my house, literally. And so I opened the garage, I came out thinking, you know, what's happening? And the police were getting out of their cars, and they were actually running past me to get to the house next door, which the houses are very close. So the person, what had happened, and I pieced it all together as time went on with the press that showed up at my house, because some of them thought this incident happened at my house next, when it's actually next door. What had happened was that there was a nice elderly lady that lived there, and still lives there. Wonderful lady. We got along great. It's her grandson who lived there with her. And I've had interactions with him. He was introverted, he was kind of quiet, but, you know, nothing that's out of the norm or out of, you know, anything to raise alarm. So little did I know that he had a paternity case with his ex-girlfriend, with whom he had a 2-year-old beautiful daughter. So the reason for that is because she never allowed any time sharing with him, because she was alleging that he had a mental illness and propensity to hear voices. He abused the pets, the family pets, and showed all this propensity to violence. So she hired an attorney, the mother, to try to file a paternity case to keep him from seeing the daughter. So that paperwork was filed with the court, and what ended up happening, in hindsight, we're again piecing all of this together, was that she finally just negotiated a parenting plan, a kind of a contract in their paternity case, allowing him to have time sharing. So what really happened from a realistic standpoint is that she had all the evidence. She had the evidence of this person being diagnosed as having a very serious mental illness. She had medical records. She had the proof of him being Baker Acted multiple times. We have her testimony that she's personally seen him hear voices out of the blue that when no voices are to be heard, and had all of these conditions. All of that was properly filed with the court. However, she eventually relented and gave in. Why? Because the system, in my opinion, was too complicated, and it's still my opinion, it was too complicated for her, somebody who didn't have the financial means to hire an attorney or find the right lawyer to make these arguments. And so she gave in and said, you know, it's so complicated, and I'll get into the reasons why. It's so complicated that she just gave in and allowed him to have time sharing. The moment he got that time sharing, he ended up taking a knife, taking the girl home, and my Ring camera shows him arriving to his house next door to mine, taking the daughter into the house, and of course, that's when he took a knife, we're finding out, and repeatedly stabbed the 2-year-old girl while they were in the house. So the grandmother wasn't home. She's the owner, remember? And so she arrived home, and that's when she found out what happened, and she screamed and, you know, called the police, and that's why they came up to my house, and the house next door surrounded our houses and launched a big investigation. And then the press came later and interviewed me. Well, did you see anything wrong with him? Were there any signals, any alarms, anything like that? And there were really nothing that you could prove other than him having a very introverted, quiet personality. He kept to himself, so nothing alarming. But this hit home for me, you know, because I saw that little girl, it was very traumatizing, being wheeled out by the ambulance. There was blood, she was pale, and they put her into the ambulance. And at that moment, I didn't really know what was going on, but the ambulance just sat there, didn't move. Then that's when I suspected this is probably past. And then, of course, the police pulled this big crime lab into the front of my house, blocking my driveway. But, you know, of course, they were doing their investigation. I cooperated, they interviewed me, and so forth. So that's where the little clip at the end where the press came that night. Again, you know, I opened my garage door and I see a row of floodlights shining on my house, but actually they were, doing their piece in front of the house of where it occurred. And of course, they saw me come out, and then that's when they questioned me. So I'm out there in my T-shirt, kind of caught off guard, but I agreed to be interviewed, and I let them know what happened. So this showed how important this whole process is, because not only did it happen here, but as a lawyer, a family law attorney, I hear things like this happening about 2 to 3 times a week. So this is a prevalent problem in our society. And our system is, in my opinion, built well enough for people to be able to assert rights to protect the children, because the courts and our legal system have a higher interest, or believe it's more important to protect our rights, all of our rights to privacy, to not be subjected to psychological evaluations, to be deprived of our right, our constitutional right. It's in our Constitution to be able to have a meaningful relationship with our children. And the courts and nobody should interfere with that, except for very exceptional circumstances. So there's a balance here. And the court system is holding our right to privacy to a much higher level to the expense of our children. And that's why I'm getting these calls and visits and consultations, people begging me to figure out how they can get sole custody of their children in, a paternity case like this, or in the divorce case. So this is a big problem. And I found out that not only is this common here, but this is one of the top topics that is researched in our website. So I speak, if you go to our website, I have a video library and articles and things that I publish of interest to the general public, one of them being this very issue. And that is the most hottest, most frequently visited question to figure out how they can protect their children against the other person, the other parent. So I've learned that that's not only common here in our community, but it's common throughout the United States. And I have some statistics from the Center of CDC, the Center of Disease Control, which publishes that there's like 4.8 million ER visits for people with mental conditions every year. 1 out of 5 adults experience some kind of mental illness. 1 in 25 of us have a serious mental illness. So these are all things that are very prevalent and common in our society. So I want to bring public awareness to everybody that this is a hot topic and how the system should work and what to do to try to avoid what happened to Melody, which is the little 2-year-old daughter who was brutally helpless. In fact, relying on the very caretaker who was supposed to take care of her, who brutally murdered her with a knife in their home, in a place of sanctuary, in a place of protection. I still get a little choked up about it because I think of, so anyway, so here's the timeline. To understand where we are today and what the problem is today, let's briefly understand how we got here. So there was a day before in the 70s where there was something called the maternal preference doctrine. That means that women, mothers in those times and before then, were favored as far as obtaining custody of their children. So women were just preferred, maybe because they're the nurturer, or they're still seen as in our society as the primary nurturer. They give birth to the child, they care for the child, and usually more involved, and certainly traditionally, and still is the case, involved in the children's upbringing. And often they sacrifice their careers nowadays, but back then, women, as you may recall, weren't allowed to work. They weren't allowed to own property like men do. But the women were then favored as far as obtaining custody and deciding things relating to the children, that we call it parental responsibility, this decision-making authority over the children. So society had this balance, so to speak, which, in my opinion, didn't really favor the women, but still, that was the balance that was struck at, and this maternal preference doctrine existed. In around the 80s, Florida adopted the best interests of the child standard, moving away from gender preferences. So as we've evolved, we're still evolving, there was a time when men were starting to argue, and I still remember as a child seeing magazine articles about men having protests saying, enough of this. Women are getting equal rights to own property, to have careers, to just vote, et cetera, et cetera. Why are we as men discriminated against in raising our children? And we have the right. Why are we delegated to being considered like some uncle that has the right to visit once in a while, and the women get all the rights to the children? So the laws started to change to recognize that men should have more rights. I'm not being anti-woman. I'm just reporting it as it was. Yeah. So let's move on to today. All right. So the term in 2008, the term custody was no longer used in Florida. We used the term time sharing. It sounds a little more politically correct in the sense that because back then women were giving primary custody and the men were kind of given like this delegated the rights to visitation rights. So it kind of seemed like anti-men and in a very social manner. So we replaced it with time sharing, and that's the term we still use today. So a person and may have time sharing with the child, and we're doing away with the custody, which seems to label somebody, one of the parents as the favored parent and the other one as like the visitor. So then today, what's happened is that the courts started on their own, giving equal rights to men for time sharing, regardless of the men's and the women's history, criminal history. They could have robbed a bank. They still don't care. Did their behavior affect the child in any way? I mean, they could be jerks. They could be difficult people, but still have rights to time sharing. So they could. There were cases where mothers begged me, saying, "Look, the man is too focused on his career, or he doesn't have time, never really cared about the kids until the separation. And so I know he's not going to take care of it. He's not mature enough." These are the complaints I hear. He's not mature enough to take care of the baby. He doesn't even know where the bottle is, or how to buy the right diapers, or be involved in the child's health care and upbringing. So still the courts just started to railroad this concept of doesn't matter, barring very exceptional circumstances, men will have equal time sharing with the children. And so they moved to that. And finally now, we've codified as of July 1st of 2023, Governor DeSantis signed into law that, and here's the key sentence. This is what happened in Melody's case. This is what's happening. It states, basically, it makes it a law. It's in a statute. Now it's codified and we codified something that the courts were already doing, which states that unless otherwise provided in this section or agreed by the party, there is a rebuttable presumption that equal time sharing of the minor child is in the best interest of the child. To rebut this presumption, a party must prove by the preponderance of the evidence that equal time sharing is not in the best interest of the child. So what does that all mean? That means that the courts are saying, boom, equal time sharing, unless somebody can prove that it's not in the best interest of the child. So this is what happened. And this is a big deal in the family law business. It's like, oh, wow. Because for the first time, it says, barring very unusual circumstances, both parents shall have equal time sharing with the child or children. And it's up to the other person to prove that shouldn't be the case because it's in the best interest of the child. So that's the thing that Melody was up against, is this big, powerful law that's out there that's now really, really mean it and written in the law. Many people come in and complain to me that they're the better parent. And it's not just necessarily the mother, it could be the father. I've had a lot of Mr. Moms come in and say, I'm the better parent. She's focused on work, or she's an alcoholic, or she's doing drugs at night, going out partying, and I'm staying here, taking care of the kids. I'm being the responsible parent. Now she's coming in and asking for time sharing in our separation. She doesn't even know, or he, the other parent doesn't even know where the diapers are, doesn't know how to do the kids' homework. They don't speak the language. I'm the better parent. I should have more of the time sharing because I know how to take care of my child better than the other parent. So, but the law says it doesn't matter. It doesn't matter if you're the better parent. So people see this law and they say, well, it's in the best interest of the child for them to spend more time with me. But that's not the case. The law says they could be a worse parent or not as good of a parent. So, but what you have to prove, and this is in Melody's case, that's what she was trying to allege, is that the other parent was unfit, was incompetent. Not only that, but dangerous, downright dangerous to the child. So she had to overcome what the law already gives to the father, which is equal rights to equal time sharing. And she had the burden to prove that the other parent is not fit. So you see, it's not about who's the better parent. It's not about you being better than the other. It's about whether the other parent is horrible or it's not in the best interest for the other parent to have time sharing. So the law says, okay, this is where things start unraveling for the parent that wants to protect their child. It has to be, here's where the law says you've got to be specific. You've got to jump through all these hoops to protect your child. Because all of us, when we go to court, there's an automatic presumption that we're competent. Doesn't matter who we are, how we're dressed, what, who you are, whether you're a celebrity or not, whatever. You're presumed to be competent. And it's up to the other side to prove that you're not. So there's the big burden. Already, Melody had all these things stacked up against her that she had to overcome in order to protect, the mother had to protect Melody from this. So let's move on to the next slide. So we look at things as lawyers, sometimes out of desperation. And we look at these arguments. Does the other parent have proper accommodations for the child? We want to make sure that the other parent is not living in a cardboard box by the dumpster, and when they have time sharing, by the way, time sharing is measured by overnights. If they have time sharing with the child, we want to make sure the child at least has basic accommodations. During a separation, it's economically feasible for the other parent or to move into a cheap place. Sometimes a studio apartment, because it's meant to be temporary. Maybe they're testing the waters for the separation, whatever. And oftentimes they move to a place that doesn't have a proper bedroom and a separate bed for the child, and so forth. So the courts will look at that. And that's the easy way for us to come after a way to limit the other parent's time sharing. But it's that's an easy fix. When they see we're alleging that the other parent doesn't have proper accommodations, what do? They find proper accommodations. They find a bigger place, an extra bedroom, whatever. If there's been domestic violence, either against the child or in the presence of the child, then the other parent can file for a domestic violence case. So the law says that if there's any physical violence or reasonable threat of a physical violence, and it's witnessed by the child, and it doesn't matter, and I've had a case where the baby was in a crib. Still, it happened in the presence of the child. The mother can file for a domestic violence case on behalf of the child to get a restraining order to keep the other parent away. So that's powerful. But again, in Melody's case, he didn't commit any physical violence towards the girl. He didn't, or threaten physical violence towards the girl or the mother. So that's where the mother's hands were tied. She couldn't really file a domestic violence case. But if there is a case where there is such a thing happening, we help file the domestic violence case on behalf of the child to prevent the other parent from coming in and hurting the child. Does the other parent have any drug abuse issues or alcoholism? Unfortunately, we live in South Florida. There's a lot of drugs, a lot of alcoholism, things like that, and it's hard to, but you've got to show a lot to the court, because imagine the argument, we come in and say, oh, wait a minute, the other parent shouldn't have time sharing because they drink. They drink a lot. Court's going to say, well, what do you mean? Alcohol is legal. Oh, well, but he drinks, when we say he drinks a lot, like he gets drunk. What proof do you have? Again, we have this high standard that we've got to prove to deprive the other person of time sharing. The fact that they drink, even sometimes a lot, doesn't mean that their behavior or anything affects the child. Now, I'm not stating any political views, but the reality here is that in Florida, we've also legalized marijuana for medical use. So I'm not rendering an opinion one way or another, but we've had cases where the other parent smokes marijuana a lot, excessively, but now when we make the allegation, what do? They get the medical license if they don't have it already. Not only that, but I've noticed that it's become so prevalent that the judges don't seem to care anymore. So what if they smoke pot? Maybe it's because more and more recent generations have been exposed to pot and marijuana more and more, and we become more tolerant of it. And maybe the judges, where this lecture is just taking place next to a park where a judge was arrested for smoking marijuana. Remember that? For pot, and I think they gave him a citation. Still, it went up to the senior judge, and then they had a discussion, and that he ended up resigning. But it happened right here, just down the block from us, within walking distance. So it's more and more difficult. And in Melody's case, he was taking a lot of other medications for his depression and anxiety and bipolar disorder, but we can't deprive somebody of time sharing because there are many people that walk among us that are on any given antidepressants or to control whatever. So that's not enough to deprive the other parent of time sharing. So the big issue for us, or in Melody's case, is to argue competency, that the other parent that lacks the ability to care for the child as a parent. So this is where the case boils down to. But it becomes hard. This is what the problem for Melody's mother. Next slide, please. So we talked about how prevalent mental disorders are in our society. And we've talked about how this is just not a minor thing, that there's 1 in 25 adults that have serious mental conditions that in often case may deprive them of their ability to care for the child. Next slide, please. So these are the hoops that the judge is going to require. So this is what Melody's mom had to do. And these are hard. The remedy has to be properly pleaded, lawyers call it, meaning you've got to put it in the paperwork. And you've got to specifically allege these facts. You can't just say generally, oh, I think he's crazy. Or generally, I think he's been diagnosed as having a medical condition, but I don't know. That ain't enough. You've got to allege specific facts. Here she did. Here, the mother's attorney did allege specific facts. History of being Baker acted multiple times. I forget, it was a lot. I think it was 12, don't hold me to that, but a lot. That he was hearing voices, and she personally observed that he's abused animals, their pets. I think they had a dog and a cat that he just beat the heck out of occasionally. So I saw that dog on a couple occasions, and now it's making sense to me. The dog was kind of slow and didn't move very well, maybe because of the result of the abuse towards the pet. So you have to state specific allegations. You have to show that the other parent has a problem that could substantially impact the present ability to properly parent that child. That's tough. How do you prove that? Past behavior. She was alleging it, but now you got to prove it. And then you have to have evidence to support the allegations. They didn't get that far, but I sensed that if she knew the number of times he was Baker acted and the medical treatment and his diagnosis, she was aware already that there was medical evidence to prove that he had the case. She just didn't get to the point of proving it, but at least they alleged it. And it must be related to a manifestation of current issues. We can't just say, oh, he was diagnosed as being depressed 5 years ago, and and being treated or was treated for that, and that's over. It has to show that it's relevant to current ability. Next slide, please. After that's alleged, now we got to go out there and prove it. So the court provides some ways of doing that. But these are tough. This is where she got stuck, Melody's mom. It's like, what? I got to prove all of this? What's worse is, what? I have to pay the lawyer how much to prove all of this? And to jump into all these hoops to protect my child? This guy's a maniac. I don't want him near my kid. And the court says, we get that. We understand that you've made your allegations, but now you've got to prove it. So they can try to get psychological, medical records and other treatment records, but guess what? He had the right to object and say, that's privileged information. Because the law protects us and allows us to seek therapy, meet with our doctors, discuss personal mental issues and diagnosis and problems without the worry of having the court system come and subpoena our records and make it public. So the court has a very high burden that Melanie's mom had to show to overcome that privilege to be able to get the proof she needed to prove the incompetence. Too difficult. The second is that the courts will allow and can impose a psychological examination of the parent. But it ain't that easy, because otherwise there's parents out there, people, lawyers, that would maliciously use the rule to force physical examinations of the other parent when there was really no need, and just to harass the other parent, or maybe just on a fishing expedition to figure out if they can find some doctor to find something to keep them from having timeshare. So the court does a balancing act and says, okay, we'll let you have a psychological examination, Melody's mom, but you're going to have to show us that there's good cause and that it has to be more than him not being a good parent. Him being a jerk, insulting, whatever, maybe not even doing the kids' homework, maybe changing the diaper as often as he should. All of that is just bad parenting. You got to show a good cause that a deeper mental condition, the court quoted here, deeper mental health condition that prevents him or her from being parenting the child in a safe and competent manner. So she has this burden, and the judge can allow a social investigator. Unfortunately, many lawyers don't know about this. And that's unfortunate. That's one of the reasons I'm here, to give public awareness to lawyers too. That the court can appoint a social investigator to look into that. This, in my opinion, would have been helpful in Melody's case. Of course, I can't second guess. I am kind of unfairly second guessing Melody's lawyer, but I know that the reason it wasn't pursued is lack of funding, lack of ability, and all of these high burdens. But that would have been something I would have done. And maybe, to be fair to Melody's lawyer, maybe that she was in the process of trying that. But they stopped. Why? Because they reached an agreement. Yes, ma'am.
If she had the ability to prove all three, would she have gotten supervised visitation or just denied him timeshare completely?
Good question. I don't really, we're going to get in deep. But what happens is, don't get me going here.
That's what you do.
That's what we do. We go in deep. All right. So even had she prevailed in proving all this, and the court's convinced, which I think at the end could have been done, had she had the monies of like Elon Musk, and she would have had lawyers all over this and done and met all these burdens. If it was a wealthier person, I think they would have been able to successfully withhold timesharing. But the court treasurers are right. to be with have meaningful relationship with our kids so much that it has to be, it won't permanently say, okay, if you win the case, it may not necessarily be a permanent prohibition against a person from having time sharing. It has to be ongoing. So if he says, let's suppose she successfully won this case, as I believe she could have, he can come back a year from now and say, oh, I'm all better now, I'm on controlled meds, whatever, and he could seek to modify or change the court order to allow time sharing, and then the court would have allowed a step up, increased a little bit of time sharing, maybe some therapy like alienation therapy, to reintegrate the parent. That's how bad the law is. They would go, even though this guy had all these mental conditions, or any given case, the man or woman has all of these mental conditions, they can come back and say, okay, I'm meeting the conditions that I need to meet to show that I'm better enough for me to exercise my constitutional right to have a meaningful relationship with my children. And he can come back and back and back and back and keep fighting and fighting and fighting until he wins, potentially.
If she knew that he had this problem, why wasn't it supervised from the beginning? Why was it just completely, okay, here's a child?
In my opinion, I'm just kind of looking at this, but I feel that this is what, the burden was so high. The hoops she had to jump through was so difficult that she gave up and just reached an agreement. Okay. And that's what I think happened. Now, nobody came and I didn't speak to the mother, and I saw her once, but I wasn't about to say, oh, wait a minute, let's talk about, I just respectfully, but I suspect that's what's happening, putting the pieces together. So let's move on to the next slide. Yes?
Yeah, it happens to me a lot when the discovery gets too expensive, and yeah, unfortunately our clients folded. And it's very, very sad. But my question is, because the stake is so high, it's the life of the child, does that happen that the judge will accept the circumstantial evidence instead of those forcing them to jump through hoops? Let's say there's no, in this case there's no spousal privilege, or the mother could have recorded the conversation to show the judge in the court he is a very dangerous person.
It's difficult. That's the problem here. It's just so difficult. And I've seen cases where exactly that happens. Because the judges in the trial court has discretion to decide the facts and make a judgment call on that. However, even if they find in favor, in this case, in favor of Melanie's mom, let's suppose she jumped through the hoops because the judge sympathized, and I get what you're saying, what if they just have some evidence? We didn't have all this mountain of evidence, but there's enough for a reasonable person to go, let's protect the child, so you know what happens? The losing party, the parent that's deprived of the time sharing, appeals and says to the appellate court, look, the trial court didn't follow the rules. The mother didn't specifically plead the issue or didn't have good cause, even if she turns out to be right. But the mother didn't pursue and jump through all the hoops, the appellate court will reverse it. And we're right back in the problem that we just had. Okay. Let's move on to the next one. How am I doing on time?
Good.
I get so caught up in this. I get really passionate about it. Because I think I'm on fire because of what happened. Okay, so maybe, all right. So here's where we are. This is the problem. We have these rights. There's a presumption of competency, like I said, and our constitutional right that is outweighing the right to protect the child. That's the problem. And we've got to fix it. In my opinion, there's, You know, there's ways of fixing the system to make it easier for the parent, but still protect us against meaningless, malicious discovery and succumbing to psychological examinations and so forth. So until that day comes where we get better in our judicial system, and again, you saw at the beginning how we've evolved, and we, thank God, continue to evolve. I think we have the best justice system in the world, but I think everybody here agrees, especially me, that it ain't perfect. It ain't perfect. But we can't stop making it perfect. So I'm doing what I can on my end to lobby for better laws and so forth. But in the meantime, we got what we got. And we got to make the best of it and fight like hell. So if the mothers of parents like Melanie can have a chance without draining all of their bank accounts, without losing money in litigation, without having to prove all of this burden, to be able to protect their child from being murdered. So again, I get a little bit passionate about this. So let's go to the next slide. So don't give up. Until that day comes where things get better, we just can't. We don't have that luxury. If it's a child's life in danger, you got to fight. You got to do what we can, which is important to find the right lawyer and get the right legal help. There's legal aid of the county that could help also provide free legal services. So, and is that the last slide? And this is pretty much the end of it. Okay, so I will open to Q&A. Oh, thank you. Thank you. Thank you. Yes, sir.
So, truth be told, full disclosure, I am in the security business myself. Cybersecurity primarily online. However, we partner with other companies that offer some technology, very low cost, to record things. So is documentation the big problem here? If you have no documentation, it won't stand up in court versus you have that in your hand.
So it depends. You know better than ask a straightforward question to a lawyer. So it depends. It depends. How was the evidence obtained? Because we can't, at least in Florida, we can't secretly record conversations. No. Now it's meaning the other party has to know and provide consent. In order for it to be admissible, you could try to do it. You can, practical, you could do it. But whether that's admissible in court, that becomes a problem.
If it's in my home?
Well, it depends. Again, so let's suppose, like me, I had a Ring camera in the front of my house that captures, whatever image it comes across. So I get a lot of weird stuff like cats and possums and whatever. And what if somebody is in front, robbing somebody in my front yard, and my Ring camera captures it? That's admissible. Okay. And like, for example, the police asked for my Ring camera because it showed the screams who was at the home and all that, which it captured the front yard to see who was in and out and so forth to help them with their case. So that's okay. That could be admissible. Okay. Again, depending on certain things. But to simplify it, yes. But to sit here, with a secret mic and get you to confess, to something, that's not legal, admissible as evidence.
How do we help the community? We have technology, if used properly, as described by the requirements. Could that help somebody in a situation? If it saves a life, I'm all for it.
Absolutely.
Right? So how do we implement it? And it's a broad question. I don't expect the exact answer.
Just in generalities, say, because we get too technical here, but right. Just in generalities, if you're in Publix, there's obviously surveillance cameras. They're not there to entrap us and to prove we're committing some illegal act. They're just there as just a security measure, right. Just like what you're doing. You install these
falls that happens every day.
Right, and then that's admissible. Because it's a public place, it's surveillance cameras, there's no expectation of privacy. and so we're recorded. If we don't want to be recorded, we don't go into Publix or whatever other market. So, but once you're recorded, that you enter the premises, no expectation of privacy. The camera, surveillance cameras, which is to be expected, captures our movement. And if we happen to do a fake slip and fall or steal something without paying, things like that, that's evidence that can be used. In this case, though, she didn't have the surveillance cameras in the house to capture, the husband's behavior. So she didn't have that. Maybe people can call and get that surveillance camera installed. You want surveillance cameras in your house. You're perfectly within your rights to do that. And if you invite any one of us to your home, and we're captured on a surveillance camera, that's okay, because you have your surveillance cameras in or outside your house, wherever you want, and then we can decide whether we want to stay there or not. Just like in Publix or whatever, we can decide not to go in. Now, do you have an obligation to do that? No, but can you if you have an elderly parent and you're concerned, or if you have a child and you're concerned about the nanny? So you're perfectly within your rights to have a nanny cam, and that's why they're called nanny cams, right? To put it. It reminds me of a story where some children, adult children, installed a camera in their father's home because he should have been in a home health facility, and he was getting to the point where he couldn't really care for himself. So the family would have this camera to check in on their dad to make sure he's okay. Unfortunately, the dad died, spontaneously. He had a massive heart attack, died in his house. The police came, and unbeknownst to them, they were caught on camera. And then, so the police came, they took the body away, and they closed up the place. Lo and behold, later on that evening, the camera reactivated to let them know there's movement in the house. So the children, or the son who was monitoring the father's whereabouts, was like, what's this? I thought, he was dead and he was the only one in the house. So they look at the camera and they see one of the police officers came back to the scene and started stealing things around the house.
From stealing from the dead.
Stealing from the dead.
That's where I'm going right here.
That's
the situation thank you, sir.
So that tape was admissible as evidence, because he shouldn't have been there. The camera was sitting there, and he just didn't think about it. And there were other things I won't get into, but So yes. So to answer your question, yes.
I have a friend who, 2 years ago, she had a child. The father of the child wasn't really involved in the child's life. And all of a sudden, when the child turned 2, he decided, I want to have visitation. When she was handing over the child was in distress because he's not used to this person. So they were crying and all of these things. My question is, if she had taped, he would have known that he's on tape. If she had taped handing over the child, showing the child in distress, would that have helped the case to not have visitation, or would it just be seen as a situation where, the child is just not used to him, he'll grow out of it?
So this happens a lot, and I have stories on both sides, and I represent parents on both sides of that. But at the end of the day, what the courts do is that, again, the parent has a constitutional right to have a meaningful relationship with their children. So it's understood that sometimes children have issues with having exchanges. Either they don't like the parent because they're not cool, that the other parent is it happens a lot. This is very common in just about every case when there's a separation involving children. One parent is liked more by the child than the other, and because one parent's the disciplinarian and the other one's kind of the Disney parent, they take the Disney, have fun. So then the child sometimes rebels and doesn't want to have the exchange. If they're young enough, we still compel, or what some courts do is they want alienation or reunification therapy, which is they're sent to a therapy center.
That's what it was, reunification.
So that would be allowed to overcome the child's reluctance and the issues that involve the child, for them to at least take steps to have time sharing.
I'm going to piggyback on that because we have somebody ask almost the same question. So if the other parent has been absent from my child's life and suddenly wants custody, can they get it? So you answered part of it, but how long can they be absent from that child's life?
Ooh, good question, whoever asked. It is along the lines of what I was answering. But here's another flaw in our system, my friends. Child support is calculated based on the amount of time sharing each parent has. What does that do? Well, the father or I keep picking on us guys. I'm favoring the women too much. The other parent, whether they're the father or the mother, has issues with time sharing, but you're entitled to equal time sharing. But if one parent gets majority time sharing, that means that parent would get either pay less in child support to the other parent, or they get more child support from the other parent. So there's this financial consideration here that forces, so if the other parent never cared for the kids, they never had time sharing during the separate, and we as people know in a relationship who really cares about the kids or not, and the other parent we know does not. And I hear this a lot, not just from women, but from some men too. And they say, "Oh my God, he didn't care," and suddenly they're coming in and saying, "I want to be the dad of the year. I want equal time sharing because I want to be the father that I never was." Guess what the court does in that situation?
Goes to intent.
They what?
Goes to intent. Like he does not really care about the child.
The intent.
No, I understood that, but I was just about to unload my answer.
I was thinking about it.
I'm about ready to give a...
She was trying to shorten it in his head.
So what happens in that case is that the courts don't care. They don't care. They say, we don't care. He, or the father, or the mom, whoever, is here today. They're saying to us, to me, the judge, that they want time sharing. And we know that probably that person has a hidden agenda. They want money. They want more in child support, or if they're the ones paying just child support, they pay less in child support. So there's an economic incentive here for Melanie's dad to say, "Oh, I want to step up and be the dad of the year so that I either pay less in child support or force mom to pay me."
So you're saying the judges are more concerned about the appeal, the case being appealed, than the real...
Right. Judges are human, and they want to follow the law, and the appellate courts have handed down the rules, and they have to follow the rules. And if a parent comes in, and we know, you could know in your heart, and this happens every day, my friends, in my office, you know in your heart that the other parent doesn't care about the kids, and you want to protect your child from that situation, unless you show these extreme circumstances, and regardless of the history of the other parent, let's suppose you prove it. Look, we've been separated a year. He's only seen the kid once on his birthday, and then he went home with his, floozy or whatever. Again, I'm still picking on men. I'm one of them, so. But yeah, it could be the woman too. And so then, in that case, if they show up in court and say, yeah, you're right, I was wrong. Yeah, you're right, I didn't have any time sharing. Yeah, you're right, I didn't show up for the graduations, the birthday parties. I didn't even call or take the child's call on Father's Day. Still, I'm here today, Judge, and I want my right I want to change my ways and be the parent that I never was. He or she is right. I was really bad, and I feel bad about it. But I'm here today, and I want my rights as equal time sharing or more time sharing, whatever. And the judge will say, okay.
If I'm getting divorced, will my criminal record affect the chances of getting custody?
That's a good question. Oftentimes, it depends. Again, straightforward question. As to a lawyer, you know better than get a straightforward answer. It depends. That's favorite words for a lawyer, right? So we have to look at the type of crime, whether there was a conviction, a plea bargain, whether it's relevant. But I'll let you know that chances are, based on what we saw here today, in large part, it doesn't matter. If it was in the past, you know, and these things come up once in a while, and we say, oh, that was all in the past. You know, they served their time or whatever, or it never led to a conviction, it was only an arrest. So we look as lawyers to say that's not relevant. Or even if it was, let's suppose they robbed a bank or something and they got convicted. That was 5 years ago. Here he or she is here today and saying they served their time, whatever, and that had nothing to do with his or her ability to provide proper child care to the child now. So chances are, and again I have to look at the specifics of your situation, but chances are that shouldn't affect your right to time sharing. In the abundance of caution, it's always a good idea to consult with an attorney who can review the specifics of your case and advise you.
Did he answer it?
You kind of already answered, but it was, do my child's preference matter in custody case?
So, it depends. Sorry. Sorry, but it depends on the age normally, and there's no, Florida law doesn't say, okay, if they're 16 they get to decide. It could be a consideration in certain instances. Normally, here's the rule of thumb from a practical standpoint. The younger the child, the less likely the child's preference is taken into consideration. And that makes sense, right? How does a baby know, or a 2-year-old, or even a 5-year-old, 6-year-old? You know, they don't like being told what to do, you know, as they get older or whatever. And so, but we can make them, and we don't really ask for their opinion. Now, as they get older, that changes the game. And I've had instances where older children will say, you know, I think this time-sharing thing is for the birds. I think I don't want to have this time-sharing anymore. What do? Oh, well, little Johnny, there's a court order here. You don't want to get the judge angry at you. What are they going to do? They're going to throw me, the child, in jail? I don't want to do it. So what I say is, okay, we're heading into a situation here, and unfortunately it's happened all too often with older children, that they decide they don't want the time sharing. They don't care what the judge says. And I've even seen some very good judges deal with the issue. I've seen a judge even take off his robe, walk around the bench, sit down at a table in a courtroom with the kids and say, look, you got to have this time sharing. I appreciate if you cooperate. And the kids say, okay, okay. In one case, they went downstairs to the lobby when a sheriff was about to take them to have their time sharing with my client, and they just took off. They ran. And they just didn't cooperate. And what's the sheriff going to do? Chase them down, handcuff them, drag them in? So what I normally say is, look, we should always, you know, barring very few exceptions, always follow court orders. If there's an order for time sharing, the parent should cooperate. So if the other parent's showing up at the door, knocking the door, asking for time sharing, you should cooperate with the court order. You have your bag packed for the child. You respond to the person knocking on the door, and you let them speak with the child to have their time sharing. But if the child says, you know, I'm not doing it, I ain't doing it, no matter what are you going to do? Call the police? No, you could. The police will come and say, what's going on? We're out here chasing school shooters and murderers. What's happening? Oh, my son doesn't want to get in the car with me to have time sharing. Well, you have this case in court, right? Talk to your lawyer, deal with it in court. But don't call us. We're here chasing criminals. Where's the crime here? There is no crime. So we're not going to bust down the door, the kid's bedroom door, and drag them out in handcuffs and put them in your car, or worse yet, put them in our police car to take them to your car or to your house. We're not here for that. You deal with it in court, call your lawyer, and leave us alone. That's what they'll do. So from a practical standpoint, well, isn't the child's preference considered in that situation? Whether you like it or not, from a practical standpoint, it comes into play, right? So, yeah. Any other questions?
What happened to in Melody's case, what happened to the murder?
He's, from what I understand, he's still in jail, and I worry because a good lawyer is going to try to plead insanity, oh, he didn't know what he was doing. Here's the evidence of the fact that he was Baker acted, he was on all these meds, had all these issues, but he's better now. And so all he needs is medical treatment. He didn't have the intent to murder his own daughter, so we got to cut him some slack. So I would think that, and I'm not the criminal lawyer, I'm not here to provide any legal advice to him or to his lawyer or anything, but I leave that to his lawyers. But I'm, from a practical standpoint, I'm the guy next door. Could he come back? Being a lawyer, I know enough not to completely trust our judicial system to be perfect, right? So could he be let out one day? Taking off my lawyer hat. No, everybody deserves justice and their day in court. From a practical standpoint, I'm the guy next door. Could he,
We can use that past information to help them maybe get an insanity plea where the mother could have used that same information to maybe have supervised visits.
Yes, sir. Yes, sir.
That same information.
Yes, sir. Absolutely. Wow. Interesting observation. You're absolutely right. Well, and then, he does have his day in court. I mean, maybe he didn't do it. I don't know. I wasn't in the house. Right. I can only surmise, and these are just based allegations. But, so we'll have him his day in court. All right. Anything else?
Good.
Yeah?
Yeah.
All right. Thank you. Thank you, everybody, for joining me today. Okay. All right. Have a great day.
Sergio.
You want to turn the lights